Joseph Kotrie-Monson is a criminal lawyer and the director of Monson Solicitors, which specialises in cases of sexual assault. He told me the disclosure of text messages in rape cases are paramount to the investigation.
The fundamental problem in any sexual offences case, Martha, is this. There is no corroborative evidence because sex is generally a private thing. You have one person's word against the other person's. So anything that indicates how they were feeling or communicating at the time is therefore incredibly important. Text messages, especially with the younger generation, every time I do a new case, there is a new way of communicating via instant messaging I hadn't heard before, and I'm something of an expert on them as a result. But you have WhatsApp, you have all these types of messages which are the single best primary evidence of what was really going on in a relationship. A mere delay in providing them, even if they're eventually provided, can lead to an innocent defendant or suspect's life being completely turned upside down for a period of 6, 12, 18, 24 months, all the way, in some terrible cases, all the way up to trial.
Has this happened with any of your clients?
Well, you can tell, of course, Martha, from the way in which I discuss this, that this is sadly a common occurrence. And while it's not the case, thank God, that cases get as far as mid-trial before somebody realises, by chance, as it appears in this horrible case of Allan, in many cases it's simply a question of waiting 3, 6, 9 or even 12 months before the police have had the resources or the time or motivation or whatever to actually get to this evidence. In the meantime, you have a young man, or in some cases a woman, who is accused of a sexual offence, who has been, whether they're exonerated or not, their life has been utterly damaged. I represented one young man who was the top of his year in anatomy, had been told that he was being farmed out to do first year medicine because he was the best student in his university, and then we end up with a situation where all that's on hold for a year, and even after he's exonerated by, guess what, the text messages which show that there was obviously a consensual element to what was going on, he then has to deal with the bureaucracy and the second part of the double whammy, which is a university investigation, because the woman is still maintaining it was rape and the university won't take into account the fact he's been exonerated criminally. Now, these types of cases, text messages, fundamentally, where you have evidence that's held by the police, it should be looked at independently and expeditiously. The money's not being spent. It's leading to, at the very least, innocent lives being substantially damaged, and at the worst, the risk of miscarriages of justice.
So what do you think is really causing this?
I think there has been a fundamental failure, Martha, to recognise the fact that the current disclosure system that we have, where the police are policing themselves essentially in an adversarial system, is one that is not fit for purpose.
So you're arguing that there should be some kind of independent assessment, as there is in civil cases? As
there is in every other type of case. In the European systems that we have, you have a magistrate who is an independent investigator. There is a role for an independent adjudicator, even in the investigation stage of a criminal case. And the idea that on financial grounds, where criminal proceedings have such far-reaching consequences, that in criminal cases we don't have that type of independent role, is frankly preposterous.